would she do this? The whole time I'm watching this interview, I'm just asking myself, why is she going on camera? Why is she talking in this interview? Why is she doing this? Why is she giving us evidence and points to keep her accountable to? Why is she giving us her plan? And the more I watched it, I realized she's priming us. She's priming her audience for what's about to come, some of the decisions that are going to be made. She wants to get ahead of this and she wants to frame constitutional education. She wants people to buy her book, watch this interview, and understand the story how she frames it, how she sets it. She's also trying to quell all of the fears and criticisms over the Supreme Court's integrity because they've made some really questionable decisions, very inconsistent decisions. And look, okay, let's say that is your reason. You want to show transparency. Well, you're not doing a good job by using the shadow docket as much as they do. Now, she explains the emergency docket or the shadow docket. It's for emergency filing of motions, not quite appeals. Not only are decisions made here temporary, but they often come unsigned, without argument, without reason, in the dead of night. And it's done rather quickly. It is not merit-based. They don't review evidence and have back and forth debates about this. It's kind of like a fast decision, which also contradicts what she herself says about the courts. In 2017, Joseph Kimball published a study surveying over 96 Supreme Court rulings in Michigan. These rulings span the year 2000 to 2015. Now, he did a really simple study. He coded the civil cases based on if the result of the case made it easier or harder to sue for relief. In those overrulings, it scored a 96.3 rating on ideologically scale. Of those rulings, Republican majorities voted in favor of making it harder to sue in civil cases, and they sided with the prosecution in criminal cases. You know, those are two motivations in the Republican ideology: rescinding civil cases and going with the prosecution on criminal cases. And that was in 2000 to 2015. So you can imagine now with all of these Trump appointed judges. So needless to say, these decisions look very political, but they're also very much abused. We had around 44 emergency dockets in 2023 to 2024, and we've already had 144 in the 2024 to 2025 period. That's over 3 times as much. And these shadow docket rulings, even without these arguments, are very confusing. You have Ken V. Holder, which explains and sets parameters for how you should navigate emergency dockets, but they don't seem to be following it. I mean, these rulings do cause irreparable harm. They do have the likelihood of success in court, especially when I look at specifically your reason for voting against it. So whose perspective do you think it is deciding that abortion isn't deeply rooted, that the idea of bodily autonomy isn't deep rooted, that it isn't substantive due process, that it's not a substantive, natural, and obvious right for human beings? Apparently not your court. But I thought you said the Supreme Court was the American people's. Ketanji Brown Jackson knew that. That's why she wrote her dissent. She was speaking for us. Now you say it's to return things back to the state, back to the democratic process, which would be a majoritarian take. But that's just selective. You had no problem taking a counter-majoritarian take. I mean, you said so as much in this interview, so why wouldn't it matter when it comes to bodily autonomy? You're characterizing the decision in Trump v. Casa like it's simple housekeeping, and you'll get to the birthright citizenship question later. But you're ignoring the fact that this has real-world consequences in the event of your temporary decision. This again violates Ken V. Holder. And why wouldn't you apply precedent here, something that hasn't been questioned since the 1800s? It's because this court is operating with a selective prudence, a selective understanding of what the values are, what the Constitution means. And when you look at what Brett Kavanaugh said about the decisions with the LA immigration raid, it's just flat out prejudice. This opinion and arguments that the 14th Amendment was colorblind blatantly ignore the historical analog, the basic framework, the basic context of why these decisions were made in the first place. So this is all gaslighting. This is all intellectual cover for being an unconstitutional, un-American radical extremist. And because of stays like this, you have mistakes like what happens in the Hyundai factory where 175 of the 475 folks detained were American citizens. And it's not just South Koreans. Every day, everywhere in America, children, adults, and elderly are being falsely detained under the pretenses of what they look like and what they speak. These people aren't just complicit to bringing about authoritarianism, they're conditioned for it. Here you have Amy Coney Barrett, who grew up in the People in Praise cult, which is literally a Handmaid's Tale cult. No, literally after the show came out, they had to stop calling the women in the cult handmaids. She actively votes against her own rights, just like Clarence Thomas. And they feign this aura of neutrality, of righteousness, of law and order, of keeping a virtuous balance in law process. But balance in this context, when you have an executive branch that is abusing and overstepping their powers, is an equal and opposite force from Congress and from the judicial branch. The courts should be just as aggressive as the executive branch is at causing these problems. When ACB talks about the reasons behind all of this, how she applies a textualist, originalist legal theory to these problems, for the people that actually understand what she's talking about, it actually hears what she's saying. She's not trying to convince you. She's giving you her modus operandi for destroying democracy. And if we focus hard enough, there are legal rebuttals there to squashing this in the courtroom. There are obvious contradictions that exist, which is why they don't write opinions and why they operate out of the shadow docket. But much to the chagrin of these cult followers like Speaker Mike Johnson and Amy Coney Barrett and Mike Huckabee and etc., all of these evangelicals, is that we don't live in an authoritarian regime. This is still a democracy, and we're going to prove that in 2026 and finish it up in 2028. So we have the tools in the Congress we need to grow this court and have voices like Amy Coney Barrett's, someone who is a victim of a cult movement, to have a little less of a voice and the American people have a larger one.